Before launching into data privacy in Myanmar, perhaps a couple of words of context. Obviously, we're in the middle of a coup in Myanmar, and so issues of data privacy perhaps fall by the wayside, although bizarrely, the coup administration has introduced some rudimentary data privacy law that I'll mention to you. So that's the first bit of context. The second bit of context is that even before the coup, I'm not aware of any actions of enforcement in relation to data privacy, in relation to any of the laws in relation to data privacy. So please bear that in mind when I actually go through the laws, that there doesn't appear to be any enforcement, at least so far. So for the agenda, you've seen that before. We're all following the same agenda, so I don't need to go through that slide. So the laws, you'll not be surprised that, in fact, my slides are very similar to Jay's slides in relation to Cambodia. The structure seems to be the same. There's no general data protection law in Myanmar. There is a constitution that is supposed to protect the right to privacy, although there's no actual legal mechanism of enforcing the constitution for an individual. There's an electronic transactions law which creates an offence of disclosing any fact in any communication without permission, and that law has in fact recently been amended to introduce the rudimentary data protection system that I mentioned. There is a law protecting the privacy and security of citizens, but significant parts of that law have in fact been suspended by the coup administration, and so they don't protect the privacy and security of citizens anymore, at least for the time being. Then we look at laws that relate to particular sectors. For example, the telecommunications law that applies firstly to telecommunications service providers, but also create a general offence of disclosing information on a secure or encrypted system. Other sectors that are affected, the insurance industry, or more particularly the life insurance industry. There's a notification that life insurance information must be kept secret or confidential. The financial institutions laws applies to banks and non-banking financial institutions with a duty of banking secrecy. And then again, similarly to Cambodia, there's a law that relates to healthcare, and there's a requirement there to keep patient information confidential. So dealing with the definition of personal data, there was until recently no definition of personal data at all. Slightly bizarrely, the coup administration, after the coup, introduced some amendments to the electronic transactions law, which introduced a definition of personal data. Why that was on their minds, I do not know. But anyway, now we have a definition of personal data, and it's defined as any information that relates to an identified or identifiable living individual. Unlike other countries, there's no distinction made between ordinary personal data and sensitive personal data. Various bodies administer this. In theory, the Ministry of Home Affairs, Post and Telecommunications Department, and then the sector regulators, the Central Bank of Myanmar, the Insurance Business Regulatory Board, and the Ministry of Health and Sports. So what rules apply to collecting it? They're now, after the Electronic Data Act, must be a personal data administrator who's responsible for securely maintaining, protecting, and managing personal data. So 2 points there. There now has to be a personal data administrator in each company, and they are responsible for actually protecting and making sure the information is kept confidential. Rules in relation to processing. The Electronic Transactions Act, as amended, requires that the PDA must not permit the information to be disclosed, informed, distributed, sent, altered, destroyed, copied, or submitted as evidence to any third party or any entity without the permission of the owner. So that implies a consent obligation. The owner, we assume it's the data subject. It just says the owner in the legislation. Secondly, making sure the data is not used for any purpose it was not collected. And thirdly, if it's over a limited period, then making sure it's destroyed after that period. There are, however, broad exceptions. Exceptions under two separate laws. Firstly, an exception under the Electronic Transactions Act if the government is investigating any cybercrime related to the stability, tranquility, or national security of the state. So now we have very broad exceptions to the data protection provisions, and of course, who will define what stability and tranquility and national security are, then that will be the government itself. And as I indicated before, next bullet point, the Section 8 of the law protecting the privacy and security of citizens has been suspended as a result of the coup, and therefore government agents can demand data from any telecommunications service provider, and it is an offence not to provide it to the government. So punishment. Punishment in Myanmar normally for offences can be quite drastic. You can see there that for the original offence under the Electronic Transactions Law of accessing a communication without permission, up to 5 years imprisonment. For the more recent offences, the personal data administrator failing to manage data properly, up to 3 years imprisonment, and anyone interfering with that data up to 3 years imprisonment as well. Under the telecommunications law, if we're talking about the telecommunications service provider, then sanctions would be administrative. So they could include, in an extreme case, the actual suspension of a license, or in fact, losing a license. And then under the specific sector-related laws, the financial institutions law, that could result in losing a banking license, although there would be warnings and steps prior to that. Similarly, in relation to healthcare services, and similarly in relation to a license to provide insurance services. So that has been a bit of a whirlwind tour of the Myanmar personal data protection regime, but hopefully I've managed to catch up a little on time. Okay. Well, data privacy as I understand it, would relate to personal data. So data privacy is the protection of personal data. So there's not really a difference between the two, but one is a function of the other. Nothing specific, no. Largely because there's no PDPA there. So there's no express restriction. Where I think it would even be difficult to imply a restriction in some of the legislation, although one can imply an obligation of consent. So one could argue that that obligation would include consent to process the information abroad.